events. And like to welcome you all. Good morning. Happy fall, everyone. I know some of you may be sad to see the summer go. And yes, with this means we are one step closer to winter. But I am happy you have sat in on today's compliance webinar on the proposed FLSA salary changes. This will be a 60-minute compliance event. And with that, we will be kind of going through a number of different segments here today. So here is the agenda that I would like to cover during today's program. Of course, we want to get and talk about the proposed changes, of course. After all, that is the centerpiece of today's program, and that is why, quite frankly, you all are here today. But I also wanted to clarify not only what is changing, but just as important, I also want to address what is not changing too. And the reason why I want to get into that is this has been a long time coming. Originally, these proposed rules were supposed to come out last fall, and then they were delayed. And then they were also going to be released in the spring, and then they were delayed once again. And now we're here today. And with that, there had been a lot of speculation regarding why things were being delayed, if there was going to be more afoot. I think a lot of people were kind of chiming in their respective blogs and articles and so forth. So we really want to use today's webinar to also clear the air on those things too, so we can really kind of provide a level set for all of you of where we stand today in September 2023 and where we're going to be moving forward with respect to that. Putting that all aside, there is more to consider than just the changes themselves. There is also the question of what their impact may have, if finalized in their current form, on your organization, and what options you may want to consider with all of that in mind. From there is also, of course, the question of the next steps that you may need to do, both to identify what the options are that make the most sense for your organization, but then what are you going to do in terms of those next steps to carrying them out, and what you should consider in that regard. Okay, so I know we have a lot of people, and I see someone that just chimed in about, are we sending out the slides after today's event? We will be sending an email out to everyone who signed up for today's program with that in mind. So rest assured, those will be coming after today's event. But on the point of next steps, you know, a bit of a spoiler alert for all of you here today. We are not, I repeat, not saying that you have to make these changes now. And I will reemphasize this again later. We are saying you need to start thinking about it, plan for it, but not execute whatever those plans are that you make at the present time. As we get into some of these considerations as to why we think you should still plan for it now, I think, you know, you and all of us will realize very quickly that even considering the scope, impact, and options that you might have to think about, just kind of going through all of that may take some time. You may need to kind of go back to your management senior teams to ultimately get to some consensus of what you want to do. And I will tell you that that doesn't happen very quickly, and nor should it be done in a vacuum. I mean, what you might want to do in kind of getting your organization to remain in compliance may not align with what others might say, and that might require you to kind of look at other options to see if everyone can be on the same page. So we're going to kind of jump into all of that here today too. And then, of course, we're here to answer your questions. And like I said before, feel free to fire those into the chat in Zoom so we can, of course, account for those today. So, with all that being stated, what is changing? I mean, that, of course, is the $64 question. Or I guess if you wanted to put a little bit of a wage and hour spin on that, it's quite frankly the $684 question. If you think about, of course, that $684 is the current minimum salary threshold anyways that we are starting from today. Where is it going or proposed to go in the future? And the answer to that question can be found here. Now, in kind of taking a step back and looking at this comparison, where we stand currently, which is in the middle column, and where things are projected to go moving forward based on the proposed rules. You know, you might be looking at these dollar amounts and going, where the heck did they come up with these numbers? Why couldn't they use round numbers? Why is it, for instance, that the proposed salary threshold, which is currently pegged at $684 a week, where did this $1,059 a week number come from? How did they arrive at that? And the answer to that question is they kind of had a method to their madness. The Department of Labor kind of pegged the number based on looking at salaried workers within the lowest wage census region in the United States, which is currently and historically, quite frankly, has been the South region of the United States. And they looked at what that number would be at the 35th percentile among the average wage for that region. And lo and behold, that's where the 1059 number came from. Similarly, but not the same percentile, and looking at the highly compensated employee salary threshold, which currently sits at $107,000, a little more than that actually, 107,432 to be precise. That 143,988 number is not looking at just the lowest wage census region for purposes of recalibrating that threshold, but is looking at all of the salaried workers nationally for that purposes. Now, I can't give you a straight answer why they decided to look at the national numbers overall versus just the lowest wage census region like they did with the more traditional salary threshold. But nonetheless, they looked at the national data for all salaried workers, and they decided to peg that not at the 35th percentile, but rather at the 85th percentile. And that's where this 143,988 number comes in. So certainly raising the bar much higher. Now, when you look at these numbers and where they're going here as proposed, they are indeed sharp increases indeed. If you were to bust out a calculator and look at that exempt administrative professional salary threshold, and I apologize, that should say executive administrative and professional salary threshold. We're talking about the threshold that you customarily use for managers, professionals, and administrators. That jump from 684 to 1059 amounts to an increase of almost 55% from where it stands now. So that's quite a jump. The highly comp employee salary threshold, that jump is roughly 34% from its current amount. But that's not the only thing that's proposed to change here. As you can kind of see here, looking ahead as proposed, there would be a scheduled series of changes moving forward. For purposes of looking at future adjustments every 3 years, they would just look at what those 35th percentile numbers are for salaried workers, for instance, who are executive, administrative, and professional. And similarly, what the 85th percentile is for all salary workers nationally. And, recalibrate those numbers every 3 years based on what those numbers are going to be, whatever that is. Now, I seriously doubt that they would conceivably go down. In all likelihood, they would go up. How high they would go up would be based on whatever those numbers look like 3 years from now, or 3 years from whenever it takes effect. So you may be sitting there wondering, did they try doing this the last time they raised the salary threshold? And the answer to that question is yes, though the last time they attempted to make these automatic adjustments, they sought to kind of do so by pegging things not at the 35th percentile, but rather the 40th. So in theory, this proposed rule now sets it somewhat lower, which I guess you could argue is somewhat employer friendlier than the last effort to try to put in this automatic adjustment. But still, if adopted, you all as employers would need to be prepared, of course, be more flexible for changes on your, pay and compensation structures, conceivably on a more frequent scheduled basis when all is said and done. With respect to that. Now, there's been a lot of talk about these changes, but what often gets overlooked by many is an option that is out there when it comes to how you meet these salary numbers. Okay, and this is something that often is kind of people lose sight of in the scheme of things for federal wage and hour. It is something that is permitted already and would still be permitted under the proposed changes currently, and I'll get to that in a minute. And that is that when you're talking about meeting the salary thresholds under the Fair Labor Standards Act, you can, believe it or not, conceivably meet it in part by the use of variable compensation. And when we're talking about variable compensation, I don't know if you've ever dealt with Patty in our office or Barb in our office, who are our compensation gurus, and they talk about compensation structures. There's this whole idea of, do we work in some incentive program as a way of paying our people? And, when it comes to wage and hour law, you can conceivably do that as a means of meeting your salary requirements when it comes to your salaried exempt workers. However, there's a cap on that of 10%, of up to 10% of the salary can be satisfied through the use of some sort of incentive program. However, when in the proposed rule, while they restate and acknowledge that that mechanism is available, I will point out that the DOL has indicated that they're reserving the right to revisit that whole avenue in the future, should, in their estimation, future experience support the need for additional changes. But right now, as the proposed rule is currently stated, this is still a pathway for you. Now, in so doing, there are conditions to that, which again, I note here in the slide. It's got to be something that, has to be paid out at least quarterly. And if for whatever reason the incentive is not achieved, there is the wherewithal of being able to do a catch-up payment to get to those minimum salary numbers within one pay period at the end of the quarter when it comes to that. So again, we don't see a lot of employers that go down these paths, but given how stark the anticipated salary thresholds are proposed to jump up, maybe, and not for all of you on the line, I know, and looking at some of the attendees here today, some of you might be working for for-profits or manufacturers where maybe there are mechanisms that make it that, or maybe you've had a past history of doing it where maybe you can kind of reintroduce those things to induce certain type of performance with your employees. But then there are also some of you on the line today who might work for not-for-profits and certain service organizations where maybe this might be a little more of a challenge for you, might be a little more counter to your culture, and maybe isn't a viable path too. So, but I just wanted to put this out there that this, quite frankly, is nothing new and still remains an option. As I've mentioned, there was a lot of speculation around how far would the Department of Labor go when it came to making adjustments to what it means to be exempt under the Fair Labor Standards Act relative to managers, administrator, or professionals. But in the end, they did not touch the duties tests that are associated with each of those exemptions. Now, before all of you take your deep breath and sigh of relief, okay, when it comes to this, that does not mean that they may not, for instance, take a more narrow point of view when interpreting the current duties tests that are in place. Some of you may know, just based on past practice, the DOL issues, for instance, what we call opinion letters. And they do so over time to reflect their views on situations that are posed to them, by employers like yourselves or others, where they're posed with questions or positions or scenario, and they kind of put those letters out there to kind of reflect their take on things. Those don't have, I would tell you, the effect of law or regulation, but it just is something to put out there just so that they can be somewhat transparent on their views. In doing those over time, they sometimes will rescind previously issued opinion letters that might have been issued before. So, be mindful of that when examining your positions, if that becomes a factor when considering options, which again, we will discuss later on as far as what you might need to do for certain jobs within your organization. So we know what the proposed revised thresholds are. What should you be thinking about then as employers with all of this going on? How do you engage your senior teams amidst all the chatter and sound bites and rhetoric that you might have been hearing over the last year or two, to kind of ground your teams and start thinking with some clarity and laser focus on what the best position should be moving forward? And what is that impact on your business too? I mean, those are going to be the questions that some of your senior team people are going to be asking of you. And for you to put your business partner hat on, if you will, to be able to kind of engage on those things from a, operational impact perspective. Before we kind of jump into that, however, you have to be mindful that, the DOL has been very upfront and transparent when it comes to the fact that, hey, this proposed rule, if it is finalized in its current form, is going to impact companies. It will hit the bottom line of employers for sure. And you can kind of see that here in some of these key statistics. We're talking about to the tune of over 3.5 million workers being affected in some way, shape, or form. And over $1 billion in what the Department of Labor calls income transfer, which is kind of frankly a new term that I've heard from this agency, which is in essence money that employers will need to shell out additionally to remain in compliance. Now, that can take obviously a couple of differing approaches according to the DOL, whether it's paying out overtime for people that may no longer be able to be considered exempt based on their current dollars. If they are still going to make the same amount of money, there might be additional overtime to be had. Or it might be in the form of additional money being put on the table to elevate salaries so that they can maintain their salaried exempt status. Either way, that's going to cost additional money to employers. It's going to hit the bottom line. The one thing I will say on this, however, is that there are other impacts as well above and beyond these two direct outcomes I just mentioned here. So, when you think about that, some employers, of course, are going to have to bear the brunt of this a lot more than others. And this is where you need to step in and shine to see where your business lies in the spectrum of things. Getting more involved with the business, getting more involved on the application of these rules as to how it hits a particular organization, because how it has an impact on the manufacturer might be dramatically different than how it's going to impact a human service organization versus how it's going to impact, for instance, someone in hospitality or retail. Some might have more jobs that might be in the crosshairs than others when we're talking about this. Your senior teams are going to want answers from you on what that impact really is going to be before they jump into, well, what are we going to do about it? So what are those next steps then? Where do you go from here when we're talking about all of this? Well, first things first, you need to start evaluating things. And as I mentioned earlier, we are not saying that you need to start changing how you're paying people right now. Because currently, as I mentioned, and as I note here, this is a proposed rule. It is not final. It is not going to take effect, for instance, in 2023. We don't know if it's going to even take effect in 2024. It could, but we can't say for certainty if it will. It's not final. It could conceivably change. And history has taught us a lesson that in the past it has. I mean, when you think about back in 2016, there was an original effort, and many of you probably recall it far too well, even though it was before the pandemic, where there was an effort to raise that salary threshold from $455 a week upwards to $913. And it was based on similar rationales of pegging the salary at certain percentiles, like I mentioned before, and even having an attempt to put in certain automatic scheduling adjustments based on Bureau of Labor Statistics data before. And then that got all challenged in the courts, and ultimately it was compromised down to the middle ground with a revised threshold of $684, which, if you were to bust out a calculator, that 684 pretty much lies at the midpoint between where the number was originally at 455 and where it was projected or proposed to go at 913. 684 is the midpoint. So, it begs the question for all of us. Might that happen again? Certainly that is something to consider in the grand scheme of things. So don't start changing your rates to the proposed 1059 figure now. You may be putting more out there than what you may ultimately need down the road when all is said and done. But we are also not sitting or saying here that you just sit idly by with your head in the sand and wait for the dust to settle, and then and only then start thinking about that. Because then you might be scrambling at the 11th hour to put something in that may not make sense. But the reality is, and let's face it, a lot of us operate in states with minimum wages at $15 an hour. And some of you might be on the line today in Connecticut. And in the case of Connecticut, based on its state law, they just announced recently that there will be increase in its minimum wage further to $15.69 an hour in light of its state law, beginning on January 1st, 2024. So when you just think about, for instance, just people that work a 40-hour schedule at $15 an hour minimum wage, that already gets them up to $600 in earnings, which is right at the doorstep of the $684 threshold that's currently in place. And I kind of put that out there to, again, think back to the arguments that were put out back in 2016. The arguments for not going up to $913 back at that time was that raising it that high so quickly would make the duties test relatively obsolete. You could make a similar argument, though not identical, that the reverse is true, or I guess the inverse is true. And that is that the current threshold, in light of the current economic landscape and minimum wage laws, makes the current rate, frankly, obsolete as well. Because basically, people almost at minimum wage are almost there to begin with. So the reality is that it will be changing. The question's going to be by how much and how do you position your organization to plan for that? Because you don't want to be in a position where you have difficulty making the adjustments that you need to your business. So with that, I'd like to kind of put a question out there for those of you. And you can put your answers in the chat. I always like to put some question out there to make these compliance webinars a bit interactive. But my question to all of you here today is this. When it comes to your fiscal year, and every organization, whether a for-profit or non-profit, of course, has some fiscal year for setting their budgets for a 12-month period. What is that? Is it run on a January 1st to December 31st cycle? Is it a July 1st to a June 30th cycle? Or is it some other 12 months? What is it? Is it a 1-1 cycle, a 7-1 cycle, or something else? If you can pipe in the chat. Oh, wow, they're flying in now. Thank you very much. That's great. Oh, we've got, I saw in October and April, a lot of July, some calendar years. Oh, a June to May, interesting. So the reason why I kind of, and thank you very much for jumping in on that, I do appreciate it. But the reason why you want to kind of take stock of that is because of also the timings that are articulated in the proposed rule. In the proposed rule, it states that the rule would take effect 60 days after it were to be finalized. Now, they could conceivably change that timeline itself in the final rule, but if the language were to remain that way in the final rule, kind of ask yourself the question, if that popped up in the middle of your fiscal year, could you make the necessary pivots midstream, since of course your budgets would have already been established, right? It's not like they could per se, when you think about that timeline of 60 days after it's finalized, yeah, maybe that might sync up with some of your fiscal years. Maybe hypothetically it's set up in a way that practically it takes effect January 1st, I don't know, 2025. Okay, well, that's great for those of you that work on a calendar year basis to plan for it. But for those of you that are in the middle of a 7-1 to June 30th cycle, you're kind of caught in the middle of your budget. Are you ready to be able to account for that? Now, I'm not saying I have any inside knowledge. I'm just kind of throwing that out there as a general example. Ultimately speaking, for some people, it could conceivably pop up in the middle of your fiscal year. So you've got to be able to pivot and shuffle your resources to make sense of what you want to do, not only to minimize the impact to your bottom line, but also be able to make sure you can continue to deliver the goods or services that you're charged to deliver on as organizations. So again, that's why we're saying plan, don't implement. And this decision-making tree is kind of giving you the steps towards that end, for us, we're sitting there saying, jump through the three blue steps we have here now, so that you can have the peace of mind of knowing what to do down the road when that final rule drops down the road. We see a lot of companies that plan for contingencies. For those of you on the line today who are manufacturers, you got safety plans. Why do you have those safety plans? In case something goes wrong, you've got a plan for quickly responding to it, to take care of it effectively. We might have business continuity plans if we, encounter disruptions to ensure that we can provide the goods and services. Why not have contingencies plans here in this side of things when it comes to the financial implications and operational and employment implications that these rules could have to you when it comes to that? So, that's why we kind of have these out here so that you can start really thinking about it. Now, you might be sitting there saying, well, how do I plan for something when I don't know what it really is? And that's a fair question to ask. But, like I said with the decision tree, the first step would be to evaluate the impact. Now, how do you go about doing that, given that we're merely talking about a proposed rule and given that we've had a past practice that has kind of changed since its original proposals? Well, model some different scenarios. Nothing that says you can't do that. Perhaps think about the impact based upon the proposed thresholds as they are currently stated. Maybe you might want to think about the impact based on what the midpoint of those changes would be. So again, like I said, currently it's proposed to go from $684 a week to $1,059 a week, and that $1,059 a week number, reaches an annualized figure of a little over $55,000. Maybe you look at the midpoint, which I've got noted here in the first bullet of this slide. And maybe you look at that and kind of identify which positions or incumbents would be affected under either one of those scenarios and what that cost would be, first of all, if you didn't do anything. If you just kept their pay at its current levels and they fell below those conceivable new thresholds, what would the additional overtime costs look like in light of the hours that they customarily work? Now, on that point, of course, that presupposes what those hours really are that these people work at your businesses. I know we deal with a lot of companies on the hotline at EANE, and we know that sometimes we, as HR professionals, key in fixed numbers into time systems just as a means of having payroll spit out the salary of our exempt people week in and week out, where it just might be that customarily you're always keying in 40, keying in 40, keying in 40, week in and week out, week in and week out, to generate the same salary. But we also know that for many of our businesses, that 40 hours or 35 or whatever you're keying into the payroll system doesn't really reflect the hours that your exempt people are really working for you. So, one of the things you might have to think about in trying to model impact is going to mean maybe you're going to have to lean on other data as well, work schedules, orders, supervisor feedback, to get a better idea and a real sense of how many hours these potential exempt people who are affected really work at your business. Because after all, you need to kind of take stock of that for you to really get a real sense of what the potential overtime costs might be if you're modeling that based on these two different conceivable thresholds here. Now, I do want to emphasize that conducting this exercise with regards to your managers, your professionals, and administrative staff affected by these changes, you could also conceivably model the same thing when we're talking about that highly comp compensated employee threshold too. So for instance, who is currently making more than that $107,432 threshold, but would fall short of the $143,988 proposed figure? Now, again, I know some of you on the line today operate in Connecticut, and it's important to know that the Connecticut Department of Labor, when it comes to its state wage and hour laws, does not recognize the highly compensated employee exemption at all. Okay. Thus, for those of you then in Connecticut, you kind of have to look at the duties test to determine whether or not they are exempt as an executive, as an administrator, as a professional. And, I've had calls with people in the past going, well, what's the difference between the highly comp employee exemption versus our traditional exemptions of managers, administrators, and professionals? The answer to that question lies in that when it comes to highly comp employees under federal wage and hour, you don't have to meet all of the duties tests in order to be exempt. Under the highly comp employee exemption, you only have to meet one of the duties tests. So it's a more relaxed standard in evaluating those people out. So to give you an example of that in practice, when you think about our executive exemption, okay, those people have to manage 2 or more full-time employees and either have the power or authority to hire or fire, or have input towards that. Okay. So for people who are classified as managers and salaried exempt, okay, you got to meet that minimum threshold, which currently is $684, or if it gets bumped up to $1,059, and that's finalized, that revised figure, but your duties tests also must all be met. With the highly comp, for instance, you could conceivably get away with just having to manage the 2 or more people without the hire to fire authority, or vice versa. You got more flexibility there. So that's kind of the difference with respect to that. So for those of you in Connecticut going, well, we got people that make more than $107,000, but less than 143. And I know Connecticut doesn't recognize the highly comp employee exemption. What do? Go back to your executive, administrator, and professional exemptions. Make sure the duties of what they're doing for you meets those standards, and you're meeting those salary thresholds there. That would be your fallback. Now, in talking about this subject further with companies, many of you might jump right into the options first to consider when thinking about what to do, and may gloss over assessing the bottom line impact. In my opinion, I would say to you that that is a mistake. As you consider some of these options here, which option or options to consider may be different for some companies versus others. Okay. And, to that end, that's going to be depending upon the jobs in question that are being impacted, and also how big those gaps really are. I mean, are we just talking about 4 or 5 employees that might be affected? Are we talking about 20 or 30 employees being affected? If the gaps in pay are a few thousand, are they a few $1,000s, or is it $10,000 or $15,000 in a gap over the course of the year? And how many hours are we talking about for the affected people? Do we just have people that are working 45 hours a week on average, or we have people working 55, 60 hours a week on average? So obviously then the question becomes, how much more overtime are we really talking about if we don't change the pay at all? Is it really a small amount of impact financially to us, or is it something much more substantial? Okay. And if we're talking about people that work in over 40 routinely due to the demands of the job, you know, maybe it's that we can bump up the salary to keep them exempt without doing anything more. Or it might be that the bump up is so sizable that we have to do more than just that. Maybe we're having to restructure the job further to justify the bump in pay. Now, I'll just say for those of you here, if you're looking at consolidating jobs with that option in mind, don't lose sight of the fact that the primary duty of the revised job, when all is said and done, still must be exempt in scope. If you're just consolidating a bunch of non-exempt administrative work, that's truly non-exempt, clerical-based type of things, for instance. Is it conceivable that you could turn an exempt job into something non-exempt just based on looking at the job in the aggregate? That's a possibility. So be mindful when you're restructuring that you're not doing so to such a degree that you're losing sight of what the primary exempt or primary duties really are, because those still need to be exempt when all is said and done. Or do you change your compensation philosophy and you go to a more variable approach? Now, when you kind of think of all of this, and the more you think about it, there are a lot of options to consider. And not only might they be differing paths for differing businesses, you might have differing paths within the same business for differing jobs, on that level too. So again, you really can't decide which option to consider until you really kind of take stock of the financial implications first. Okay, I had a question come up in the chat. What about sales staff who get commission? Remember, outside sales are not affected by this rule change. And as a consequence, if they truly are outside sales that are paid on a commission basis, they can still remain exempt. If you're talking inside sales, telemarketers, they're not exempt historically under Fair Labor Standards Act at all when it comes to that. So when we're talking about the salary thresholds in today's compliance webinar, talking about salary rules relative to executive, i.e. managers, administrative people, and professional people, and the highly comp person too. Okay. So then there are the other impacts and responses you need to decide upon. Okay. The question really is going to be, okay, you identify the jobs that are directly affected, but then there is the ripple effect. Does it create pay compression issues elsewhere? I don't know, and I guess I'll put this question in the chat. I put this question out there and feel free to chime in the chat. Do you folks have formalized compensation programs? Do you have some sort of a point factor system? Do you use NPEP? Do you use HAY or some other formal defined plan? All right, some of you are chiming in no in the chat, and that's okay, but be mindful. Okay, a couple of people saying they've got some in-house developed compensation. Okay, so we got a little bit of a mixed bag here. Even for those of you that don't have formalized comp programs, if you think it through, if you're having to raise salary thresholds to keep the exemption from some, is that starting to bump up with pay elsewhere? Based on, whether those people are pegged at other salary amounts due to a formal comp program or otherwise. Because if the concern is we're still wanting to preserve some internal pay equity amongst our staff that's being employed overall, there is then that derivative impact that raising certain jobs might have on those other people. You might face pressure to raise other pay levels too, to maintain gaps from one job to the other. Okay. And then there's those other costs that come with all of this. I mean, when you think about vacation, sick, or if you got PTO or earned time, all of that paid time off is historically pegged at what? Someone's typical rate of pay. So if those salary thresholds are going up there, it's going to affect those additional costs of benefits. And then for those of you who have retirement plans, 401ks, 403bs, you might have formulas that are based on what people's earnings are. It's going to impact those things. If you have matching formulas in 401ks, it's going to impact those. So again, there is simply looking at it from a, well, are we going to have more overtime costs to our bottom line? But it's also going to hit these other, topics and those corresponding line items on your budget as well. So when you really kind of, tally all of this up, the cost can be a lot higher than just directly the overtime costs. So that really then begs the question, well, how do we really take this all in? Are we going to just absorb the full impact of these changes, thinking of all of these factors? Or are we going to pass it downward somehow? What I mean by pass it downward, I'm saying pass it downward to your customers or clients or consumers, or call it what you will, depending on your organization. Okay. Are we going to adjust our prices, our fees, or what have you? Are we going to kind of split that? We're going to absorb some of it. We're going to pass some of it down because we don't want to lose our market competitiveness in terms of our services that we provide. So again, here too, differing people on your management teams might have differing points of view on these causes and effects. All of this then therefore needs to be a part of the calculus when you are truly trying to formulate a plan that makes the most sense for you. It is indeed not a one-size-fits-all solution, regardless of what that salary change ends up being in the end. So again, the advice that we at EANE would say is plan, don't implement at the present time. Think of all of these issues. Think of all of the impacts. Think of the potential options of modeling based on the proposed rule and maybe a smaller, potential bump up, whether you look at the, just looking at a potential midpoint bump up, figure what those additional costs would be, and then figure out what makes the most sense. And then collaborate with your teams and have your contingency plans then kind of tucked away so you can pivot. Now, some of you might say, again, when might this all become a reality? Like I said earlier, it's not going to be finalized by the end of this year. Okay. They're open to getting proposed, they're in this position of evaluating comments. They've got that period of time to go through. There are going to be hundreds, if not thousands, of comments to go through. And they've got to go through that under rulemaking before they can finalize a rule. And only then would the 60-day clock start. Now, realistically, that's not going to happen before the end of this calendar year. The real question is going to be with 2024 is going to be, will there be some litigation afoot to challenge the legitimacy of the proposed rule, seeking a proposed injunction? Historically, there have been cases when these type of efforts have happened in Texas or Louisiana. You get Southern district courts in the federal court system that are viewed as more employer or conservative friendly to try to slow things up. And that very well could happen. But again, it hasn't happened as of yet. And then the question then is going to be, how much would those be fast tracked into the court system to challenge it and go up the circuits? And then the question then would still be, when all of that is said and done, who's in power at the White House to be able to respond to those things? Would it be one that would be more supportive of the current proposed rules in effect, or one that may not be as sympathetic to what the current proposed rule is? Because that would determine whether or not it could be shelved, or, like the last go around, implemented in a more compromised middle ground approach through legislative pressure or otherwise. So again, there's a lot to be said on timing, but I think there are a lot of market pressures to drive some change. And I think the 2016 history, I think, provides a telltale lesson of what we might expect this go around. So that is what I wanted to cover here today. I'm just looking here on the chat and the Q&A features of Zoom to see what questions we might have. And again, I do thank you all for Sue Layton. Question: is the salary threshold prorated for part-time employees? The answer to that question is no. That number is the number regardless. So, some people will say, well, can a part-time person conceivably be exempt from overtime under FLSA? As long as they're meeting the minimum threshold, it is, but it's not a function of the hours that they work. When will they announce the final timeline? Knowing the date or at least the quarter of when it will go into effect would be important for planning. I totally get it on that. I wish I had a crystal ball on this. And I think anyone that would try to give you a straight answer on this is kind of glossing over two things. Number one, how long it's going to take them to go through all the comments. Number two is what sort of legal challenges might come afoot to hit the pause button on this. The last go arounds, you had legal efforts designed to slap what we call injunctions to kind of put things on hold. Both of those things can derail timelines on this. Again, this is why I come back to the question of, I think you still have to plan for contingency plans regardless. Because if you're waiting for the announcement of a final rule, when you think of all of those variables to really think about, and I know some of you who are not-for-profits, the one thing I didn't bring up, of course, is you might have to deal with boards, finance committees. Forget your internal staff. You might have those dynamics to work your way through too. So I think, when you think of all of those things, you at least have to have drafted ideas. This is what it's going to be if the number finalized where it stands today. This is what we're going to do or think about doing if maybe it comes in at the midpoint or some other number. And at least that way, you can kind of start stewing as teams to say, are we comfortable with these? Are we missing something in our evaluation scheme of things? And then kind of set them aside and at least know, whatever might come afoot at the end, we got a game plan to respond to it. Again, kind of like I use the safety analogies as illustrations of that, but I think it makes sense with that, because I don't think I can give you any sort of a hard, fast date of saying it's going to be announced by XYZ date in like 2024 instance. It's just there's still a lot in flux with that. Okay, seeing if there's anything else. Don't see anything there. Someone asked about credits. I would contact our training team, Caddy, in our office. as far as training credits are concerned for today's event. If we don't have a code, you can certainly just use our narrative summary. It wouldn't qualify for strategic credits, though. It would be general credits in scope, that I can tell you. Anything else? I don't see any other questions. Either way. Oh, wait a minute. Oh, another question on proration. Again, it's not proration. Question on meeting the salary threshold. Are matches counted towards that? The answer to that question, no. It's basically design. It's just incentive, variable bonuses or commissions to that end. Matches don't count. Okay. That looks like everything I see for questions. So I'd like to thank you all for joining us here today. I mean, as you can see, this won't be the last you'll hear from us on this. We'll continue to monitor the situation and how it evolves during the remainder of 2023. And of course, keep you abreast of those changes through our e-alerts and beacon and whatnot. I know it'll be a topic for conversation probably at some of our roundtables that we've now launched for the 2023-2024 year. But again, we hope that in the interim that we've given you some insight and guidance that you can take to your own operations to prepare and plan for the future, because things will be changing at some point. So like you all to enjoy the rest of your day. Take care. And if you have company specific questions, there's always the hotline for all of you. That's of course a benefit of membership. So enjoy the rest of your day, everybody. Bye now.